Institute. I'd like to welcome you to today's conference, and I would like to thank the United States Bankruptcy Court for their generous support in hosting the conference, as well as UNCITRAL Secretariat for providing support and planning this conference. It's my privilege to welcome Chief Judge Insolvency Institute. I'd like to welcome you to today's conference, and I would like to thank the United States Bankruptcy Court for their generous support in hosting the conference, as well as UNCITRAL Secretariat for providing support and planning this conference. It's my privilege to welcome Chief Judge Glenn to the floor. Thank you.
I'll be very brief so you can get on with this important work. But on behalf of the Southern District Bankruptcy Court and my fellow 8 judges on this court, I'd like to welcome you to this conference organized by the International Insolvency Institute, marking the 5th anniversary of the Model Law on Recognition and Enforcement of Insolvency-Related Judgments. And I know that many of you have spent the last week here in New York at the United Nations on the important work of UNCITRAL's Working Group 5. And from the attendance sign-up sheet for the conference today, I'm pleased to welcome people from around the world, including from, there's 26 countries, Albania, Argentina, Austria, Brazil, Burkina Faso, Canada, Cayman Islands, Chile, Colombia, Czechoslovakia, England, France, Germany, Israel, Korea, Mexico, Netherlands, Nigeria, Poland, Saudi Arabia, Singapore, Spain, Switzerland, Trinidad and Tobago, and of course the United States. And I apologize if I've missed any of your countries. The point is, of course, that we live in a global economy, and financial distress does not respect international boundaries. UNCITRAL Working Group 5 continues to work to harmonize international approaches dealing with financial distress, to maximize the value of distressed businesses, and to assure a fair distribution of that value to creditors and investors. And the Model Law on Recognition and Enforcement was adopted in July 2018 and designed to harmonize procedures for recognition and enforcement, and in doing so, complementing the work of the Model Law on Cross-Border Insolvency, of course, which we've had in the United States since 2005, and we have many of those cases here in the Southern District of New York, and I think I've been fortunate to be able to deal with many of those issues. So I'm looking forward today to learning more about the important subject of this model law and the distinguished panelists from whom we'll hear. And following the program, I look forward to speaking with many of you during the reception in the beautiful rotunda of the Museum of the American Indian, which is also housed in this building. And it's so good before we got started today to see so many people that I've met in various places around the world and in the United States. Again, welcome to all of you. Thank you to the International Insolvency Institute, and enjoy the conference and reception. Thanks very much.
Next, I'd like to welcome, as many of you have known, he just wrapped up a week of expertly presiding over Working Group 5, Mr. Harold Fu, who has been the chair of Working Group 5 since the 56th session in December 2019. Harold?
Thank you, Evan. Good morning to everyone. Chief Judge Martin Glenn, distinguished guests, ladies and gentlemen. It is my great pleasure to be here with you all today. And as you know, UNCITRAL's promulgation of the model law on cross-border insolvency in 1997 has transformed the field of international insolvency. And we celebrated last year its 25th anniversary, and its history and practical impact is well documented. Enhancing UNCITRAL's insolvency ecosystem is the model law on recognition of insolvency-related judgments. And as Chief Judge Martin Glenn mentioned, this forms the basis of our discussions and conference this morning. It provides a framework for cross-border recognition of insolvency judgments, and it also addresses any lingering uncertainty as to the application of the model law on cross-border insolvency. And in lifting the curtains for this morning's discussions, I thought to share two brief comments, being part of the working group at that time that finalized this instrument. And the first is that this model law provides flexibility to states as to the process and how it can be adopted. And the rationale and the importance of this can be seen through the preparatory process that led to the finalization of this instrument. And as many in the room were involved in this, I think we would all recall that discussions were complex and difficult, and it was finalized amidst a diverse slate of issues, including jurisprudence that differed on the interpretation of the 1997 model law on cross-border insolvency. And therefore, recognizing this, the instrument provides flexibility to states to adopt the model law accordingly, depending on their individual circumstances. And the second, I would like to emphasize that the working group was very careful in its deliberations to ensure consonance with existing practices and existing instruments. And I think that many of these themes will be elaborated on by the excellent slate of panelists and speakers that we have this morning, and I hope that this conference will be a platform for us to continue and further these discussions. Issues such as features of the model law that facilitate successful outcomes, as well as strategies for implementation for states. And besides the direct benefits of adoption, the model law on insolvency judgments has broader salutary effect, and it contributes to the ongoing development of international insolvency law, the ultimate goal of which is to harmonize, to the extent possible and where appropriate, the rules and to facilitate better outcomes for all parties involved in transnational insolvencies. And to this end, as a number of you have mentioned before me, the working group continues its work in this area on two important projects: the first, civil asset tracing and recovery, and the second on applicable law in insolvency proceedings. And the working group has completed 4 days of intense and difficult discussions. I think that we can all agree we have made an important step this week, and we look forward to continuing our discussions in Vienna in December. And a number of these themes and topics that arose in the last 4 days are equally applicable to the issues that we are discussing this morning, given the impact on recognition and enforcement of insolvency judgments. And with that, I would like to wish everyone and all of you a fruitful exchange of ideas this morning, and thank you very much once again.
So next, as they walk to the floor, we'll start with our first panel, which will deal with the drafting and the origination of the model law. I'll turn it over to Stacy Lutkus, who will be moderating.
I'll stand here. Good morning, everyone. I'm Stacy Lutkus. I'm an attorney at McDermott, Will & Emery here in New York, and it's an honor for me to moderate this panel of experts. Starting with my immediate left is the Honorable Allan Gropper. He was appointed as a United States bankruptcy judge here in the Southern District of New York in 2000, and he retired from the bench in 2015. He is a member of the National Bankruptcy Conference and a fellow of the American College of Bankruptcy. He's a member of the MLIJ Judicial Committee and is also a member of the United States delegation to UNCITRAL Working Group 5. To Judge Gropper's left is Susana Hidvegi. She's a business insolvency, complex litigation, and arbitration advisor and is the former chief judge of the Columbia Business Bankruptcy Court. She previously represented the Republic of Colombia at UNCITRAL Working Group 5 and is a current member of the III UNCITRAL Working Group 5 committee. She has lectured on bankruptcy law in myriad postgraduate programs at several universities in Colombia and also led reforms to the Colombia bankruptcy regime to address the effects of COVID-19. To Susana's left is Irit Mevorach. She's a professor of international commercial law at the University of Nottingham, where she also serves as co-director of the University of Nottingham Commercial Law Center. She teaches and researches issues in corporate law, enterprise groups, insolvency, cross-border insolvency, and bank resolution. She serves as an expert advisor to the UK delegation to UNCITRAL Working Group 5 and as the UK national correspondent on case law on UNCITRAL text. She's also a member of the UNCITRAL Working Group on Bank Insolvency and serves as a co-chair of Subgroup 3. She also previously has served as senior counsel at the World Bank and led the bank's global initiative on insolvency and creditor-debtor regimes and its global task force on insolvency and creditor rights. She previously represented the World Bank at UNCITRAL Working Group 5. And then to Irit's left is Professor Dr. Rodrigo Rodriguez. He's a professor of civil procedure law specializing in debt collection and bankruptcy at the University of Lucerne in Switzerland. He currently serves as head of the Swiss Federal Supervisory Authority on Insolvency, as president of the Swiss Federal Commission for Debt Enforcement and Bankruptcy, and as representative for Switzerland to UNCITRAL Working Group 5, as well as in the Judicial Cooperation Steering Committee of the Council of Europe. He's an advisor to the World Bank Group, a board member of Insol Europe, and chair of the Insol Europe Academic Committee. Pedro, if you could just go to skip the next slide. That's our panelists. And starting with the first slide. So we are here on the observance of the 5th anniversary year of the model law on recognition and enforcement of insolvency-related judgments. So let's start at the beginning. In 2014, the UNCITRAL Commission gave Working Group 5 a mandate to develop a new model law or model legislative provisions to provide for the recognition and enforcement of insolvency-related judgments. Susana, how did we get to that point where UNCITRAL recognized the need to develop such a mandate?
Thank you very much, and thank you to the United Nations UNCITRAL, the United States Bankruptcy Court for the Southern District of New York, and the International Insolvency Institute, and to my distinguished co-panelists and Stacy for moderating this panel. So the background for the UNCITRAL model law recognition and enforcement of insolvency-related judgments, I would say that has two main reasons. One would be the lack of regulation and that there are no international conventions specifically dealing with these matters, and actually those conventions expressly exclude the application of these two bankruptcy-related judgments, and that there are some cases that, as Mr. Fu mentioned, somehow misinterpreted the application of the model law. So with regards to the instruments that exclude the application for insolvency-related judgments, we have the A Convention, where Article 1, subparagraph 5 expressly says that it does not apply to questions of bankruptcy, composition, or analogous proceedings, including decisions that may result in validity of the acts of the debtor. And also the Lugano Convention that Rodrigo will explain further says that it does not apply to bankruptcy proceedings relating to winding up of insolvent companies or other legal persons, judicial arrangements, compositions, and analogous proceedings. So, with this in mind, the first case that I would like to mention is the Robin case against the Eurofinance. So this was actually a case from the U.S. Federal Bankruptcy Court for the Southern District of New York. It was a judgment of about 10 million against Eurofinance with respect to some fraudulent conveyances, and that judgment was sought to be enforced in the UK. So the company Eurofinance, the defendant, was a BVI company, and it was set under the laws of England, and the trustees were actually resident in England. So based on the model law, with this judgment, the receivers went to the UK courts and asked for recognition of the proceeding, the Chapter 11 proceeding, and the recognition of them as foreign representatives and the enforcement of the judgment. So the UK court in the first instance held that although Eurofinance did not appear to that proceeding, it was related to the insolvency proceeding, and therefore the case, the judgment was recognized. But the decision was subject to appeal, and the issue was whether, and if so, in what circumstances, an order of a foreign court, in this case the US court, in a proceeding where it involved the clawback or the set-aside transaction, could be recognized in the UK. In the appeal, the Supreme Court, by a majority of 4-1, allowed the appeal and considered that this cannot be recognized in the UK, and this is the main holding. The court said that the decision to give effects to a foreign decision must be a matter of the legislative and not of the innovation of the courts. So in that sense, the court reviewed all the instruments that it could apply for recognition of a foreign decision related to an insolvency judgment, and in the end, the decision was that it cannot be recognized if it's not a decision of the Chapter 11 itself, but a related judgment. So that's one of the reasons where this model law will be relevant. And also, there is also a case, the Sabina case. On December 2009, the Belgian government filed an application against Switzerland before the International Court of Justice, arguing the refusal to apply the Lugano Convention with regards to a proceeding that was being trialed in Belgium. So the Swiss court refused to apply or to recognize that judgment because it was a decision that was not final. It was a judgment that was still going, and the Swiss court held that it had the same purpose of something that should be done within the insolvency proceeding that was being pursued in Switzerland. So in the end, the Belgium waived this petition. So in the International Court of Justice, this did not made a ruling, but in the end, it showed that there could be some issues regarding the application in connection with judgments that are not specifically part of the insolvency proceeding. And there's also a case from Korea from 2010, where the Supreme Court of Justice argued or held that it's possible to recognize a proceeding, a foreign proceeding, in this case a Chapter 11 proceeding, but it does not mean that it will recognize all the decision made in that case. So what the Korean court held is that the bankruptcy court's powers will not extend to assets that are located in Korea. In that case, then also arises the same issue. And just to close, I would like to mention a case in Colombia. It's a 2022 case. So it's a vertical deviation case. It was an international arbitration award, and it was not recognized yet through the homologation proceeding before the Supreme Court of Justice. So the bankruptcy court refused to recognize that claim based on the fact that the arbitral award was not yet recognized or homologized under Colombian law. So I believe that this could have been dealt with a model law. Thank you.
And so, so the described case law, Susana, it highlights the perceived, at least by some courts, gaps left by the model law on cross-border insolvency. And so UNCITRAL developed this, the UNCITRAL Commission developed this mandate. And what exactly, Irit, did the UNCITRAL Commission set out to have Working Group 5 develop? Pedro, if you could just skip 2 slides, please. I'll be better.
Next one, yeah. Yes, thanks. So what we see here is first the preamble to the model on judgments. So just to sort of recap on what Stacy explained well, the international community and UNCITRAL working group that deals with insolvency matters on the international level was convinced, following those series of cases, Rubin and other cases in other parts of the world, it was convinced that there is some gap, or at least uncertainty, in the model on cross-border insolvency, especially the relief provisions. To what extent we can use the relief provisions to recognize and enforce orders and judgments emanating from the insolvency forum. And also, in addition to that, at the same time, there was an acknowledgement that we need more tools to facilitate asset tracing and recovery, and it was recognized that the model on cross-border insolvency is helpful in this respect, but perhaps it isn't enough because of those uncertainties and gaps regarding enforcement of judgments and orders, including those related to the asset tracing and recovery tools, and because not all countries have adopted the model on cross-border insolvency. And it was also recognized, as Stacy mentioned, that no one else is going to do the job for us, no other organization that deals with generally commercial and civil law matters like The Hague. So the Hague Convention excludes insolvency, and rightly so, because insolvency has its own unique characteristics. And so we had to deal with this matter, and the aims in the preamble reflects this idea of complementing the framework for cross-border insolvency, and in particular the model on cross-border insolvency, and addressing specifically the issue of recognition and enforcement of insolvency-related orders and judgments. And if we look at the next slide, so we see the main features of this model law on judgments. So we now have a specific model law that deals explicitly with the recognition and enforcement of insolvency-related judgments. And so it has a set of definitions. Some of the definitions that we see there are similar to definitions that we already have in the model on cross-border insolvency, but there are also unique definitions unique to this particular instrument. So a definition of a judgment and an insolvency-related judgment. So you see the definition in the slide. And then there is the procedure for seeking recognition and enforcement of judgments and then granting the order for the enforcement of the judgment. So the idea is that the insolvency representative or another authorized person will seek the recognition and enforcement of the judgment, will provide the relevant documentation, will show that this is a judgment related to insolvency and that it is enforceable, it has effect in the court of the insolvency representative, in the home court, in the originating court. And then if that is the case, then the receiving inbound court should recognize and enforce that judgment if it meets that criteria and subject to safeguards, subject to public policy and additional potential safeguards or grounds to refuse recognition and enforcement of judgment. And there is a list of such grounds to refuse recognition and enforcement of judgment listed in the model on judgment. So in addition to public policy, there are public policy related other safeguards related to public policy like fraud, lack of notices, also adequate protection, also specific safeguards related to judgments like inconsistency with the previous judgment or where the judgment the enforcement of the judgment will interfere with the insolvency proceedings. And there are also jurisdictional grounds to refuse recognition and enforcement of judgments. And these grounds include the general grounds that we find in general conventions on private international law enforcement of judgments, so a lack of submission or presence of the defendant. And then there's also generally incompatibility with the law, the private international law of the inbound receiving court when the jurisdictional basis of the originating court doesn't comply with the local court's laws, then you may refuse the recognition and enforcement of the judgments. Then there's also an Article X at the end of the instrument, at the end of the model on judgment, which is a statement regarding the model on cross-border insolvency, stating that the relief provision, the discretionary relief provision in the model on cross-border insolvency, Article 21 of the model on cross-border insolvency, does allow to recognize and enforce insolvency-related judgments. And so in the next slide, what I show there is that what we have now is two instruments that are relevant to the recognition and enforcement of insolvency-related judgments. And that creates certain overlaps and potential inconsistencies or uncertainties that it is good to be aware of as we are starting to try and operationalize and potentially adopt the model on judgments. So overlaps because both the model on judgment and the model on cross-border insolvency deal with recognition and enforcement of judgment, as is clarified now in Article X of the model on judgments. And in both there are safeguards and similar safeguards regarding public policy and adequate protection. But then there are also differences, and one difference is more notable, but in my view less important. The other is less notable, less noticeable perhaps, but potentially more important. So one difference, clear difference, is that the model on cross-border insolvency relief provision, other than the stay that is automatic following recognition, all the rest of the relief is discretionary, and that is included, and that includes the recognition and enforcement of insolvency-related judgment, which is now clearly part of Article 21 following Article X. So this is discretionary, while under the model on judgment, if you meet the criteria, you seek the recognition and enforcement of the judgment, then it should be recognized and enforced. So it isn't discretionary, it is a requirement. And that is fine. It potentially provides options to countries. Some countries may prefer a more straightforward requirement to the court to recognize and enforce a foreign judgment. Others may prefer a more discretionary regime. In my view, the difference is not so material at the end of the day, because also under the model on cross-border insolvency, the idea is not just to provide a very open-ended discretion to the court to do whatever they like, but rather the idea is that you tailor the relief to the particular circumstances. So not in all circumstances you need to automatically recognize judgments after recognition of the main proceedings. It depends on the circumstances and what is being sought by the insolvency representative. And so if this is what is being sought, the enforcement of a related judgment following recognition of a proceeding under the model on cross-border insolvency, then it should be granted subject to the safeguards, public policy and adequate protection. And similarly, under the model on judgment, it's not that you are always required to enforce a judgment. You need to meet the criteria, and there are also safeguards. The other potential inconsistency, in my view, is a bit more problematic, and so we should pay attention to it as we consider adoption of the model on judgment and perhaps the model on cross-border insolvency if it hasn't been adopted yet in the country, is that the safeguards are slightly different, and in particular the fact that the model on judgment adds this set of jurisdiction basis for refusing recognition enforcement of judgment. So under the model on cross-border insolvency, you first decide whether to recognize the proceeding as main or non-main proceedings, and in particular, following the recognition of the proceeding as main proceeding, there is a stay, and then you tailor the relevant relief, and you may enforce the judgment based on Article 21, only subject to public policy or adequate protection. You don't then, again, consider whether the jurisdiction was appropriate because you already recognize the proceedings as main proceedings. Whilst under the model on judgment, there is a list of safeguards, including jurisdiction basis, which are quite vague. So other than presence and submission, which is not particular to insolvency, other than that, we are talking about incompatibility with the local law. This isn't uniform, and the risk is that courts may then say, if they are just looking at the model on judgment, detached from the rest of the framework, they may still be reluctant to recognize and enforce judgment emanating from a main proceeding, thinking that perhaps this is not compatible with the local private international law related to insolvency. And so next slide, we can acknowledge that the model on judgment isn't perfect, the model on cross-border insolvency isn't perfect, our model law system isn't perfect, but they say that seeking perfection is a fantasy, and we need to make the most of what we have, and in my view, we have some good options here. The less good option is not to do anything, to ignore the model laws on cross-border insolvency, on judgments, or on groups, which we are not dealing with now. And I think that is the case also with regard to countries that didn't have an equivalent Rubin problem or other cases similar to Rubin. Still, adoption of the model law on judgment, I think, will be useful, will clarify the scope of the model law on cross-border insolvency and generally of our framework related to enforcement of judgment, and will notify and clarify to parties coming from other countries what is possible based on the model law framework. It can also give example to other countries and encourage countries around the world to follow and take part in the model law system. So in terms of options, one option would be to look at the model law on judgment separately and to adopt it as a standalone, separate instrument. And in that process, if the country already adopted the model on cross-border insolvency, it may also want to clarify through the adoption of Article X that the model on cross-border insolvency relief provision also allow to enforce judgments related to insolvency. And then ideally, in addition to that, provide some guidance to the courts to say, in line with the international framework for cross-border insolvency generally and the concept of modified universalism, the idea of supporting mainly a main process, to say, well, if the judgment is coming from a main proceeding, then that is enough. You don't need to consider the jurisdiction basis again. The other option would be to integrate the model on judgment within the model on cross-border insolvency if that is already enacted in the system, or if it is going to be enacted alongside the consideration of the model on judgment. So the two instruments can be sort of merged, and specifically through clarifying Article 21, specifying that it includes the recognition and enforcement of judgment, and then ideally also adding the relevant specific definitions to say what is an insolvency-related judgment and what is the procedure for seeking an enforcement of such judgment, and then adjusting the safeguards accordingly. So adding those safeguards that are specific to judgments in consistency with the previous judgment, for example, and then that is it if it is a judgment coming from a main proceedings. We can then also add some specific provision just to deal with the circumstances where the judgment emanates from proceedings that are not main or non-main proceedings, and add those additional jurisdictional bases to deal with those specific situations. Now, final word just to say that it is encouraging to know that countries have started to consider the adoption of the model law on insolvency-related judgment, and to the best of my knowledge, the UK is the first one to have started a consultation process back in July, both on the adoption of the model law on enterprise groups and on the adoption of the model law on judgments. And with regard to the model law on enterprise groups, the idea is it is proposed to adopt it as a whole. With regard to the model on judgment, there are more nuances as to how to adopt the model on judgments. And Mark Smith from the UK delegation and also Andrew Shore from the Insolvency Service and the Business Department are here. And perhaps Mark would want to say a word about what is going on in the UK, whatever he can share with us in terms of the consultation process. I don't know if you want to do it now or maybe at the end. But if Mark agrees, perhaps he can say a word about the UK consultation. Is that okay?
I don't know if Mark knew this was going to happen.
Mark does know, and he's willing to say a few words.
Well,
He was yesterday. He may have changed his mind today, but he was willing to say where the UK is. It is the first to seriously consider adoption of the model law on judgment enforcement. Maybe I can simplify this a bit. The Rubin case in the UK basically holds that the model law on cross-border insolvency does not cover enforcement of a foreign insolvency-related judgment, such as the judgment in the Rubin case, which was a garden variety preference or fraudulent conveyance case in the United States. So a gap was found. We in the United States do not recognize that gap. We enforce foreign-related judgments under our model law on cross-border insolvency, which is, as you well know, of course, Chapter 15. Judge Glenn has decided multiple cases. He's really the source of our jurisprudence on the ability to bring a cause of action in Chapter 15 based upon foreign law and pursue that judgment in the U.S. against defendants who are found here, because some parties can only be sued in the United States, but they're being sued basically based on English law or Norwegian law or many other legal systems. So we don't see this gap. Frankly, I don't know, and maybe Irit can explain later, where the English concept comes from, that the model law is only procedural. After all, did UNCITRAL work on it for 10 years and come up with a document that does nothing more than issue a stay based upon a foreign insolvency proceeding? Because that may be all you have in England. In any event, it was the Rubin case that got us working on this. I think it is brilliant to adopt this law as an amendment to Article 21, Section 1521 of our Chapter 15, which provides for relief. And the English courts have found that, well, as I think Suzanne said, you can't enforce a foreign discharge, or you can't grant relief that's available under foreign law if it's not available under UK law. That's the UK Pan Ocean case, which isn't a Supreme Court case, but it is law, I believe, in the UK. I state UK law with trepidation. We don't narrow the model law on cross-border insolvency that way in the United States. And we also hold that we will recognize foreign judgments. That raises the Gibbs rule, which I think we'll come back to later, because that's really another issue. But the view in the United States is we really don't need Article 10, but it wouldn't harm, it wouldn't hurt, and I think it would be useful and perhaps begin to get some interest in adopting the model law. But I'm interrupting, or I'm talking too long, and we should let Mark say a few words, if that would be all right.
We should let Mark say a few words.
You want me to do it from here?
Wherever you'd like, I think.
Yes, yes, we can hear you.
Can you hear me all right? I'm Mark Smith. I'm the lead government lawyer in the UK, advising the Insolvency Service, and my colleague Andrew, hiding away down there, has left me to do this. So where we are is we've consulted on an approach on the Judgements model law, which is a bit of a hybrid. It would involve implementing Article X, and it would also involve bringing in some of the procedural guidelines for the court to follow. It will come as no surprise that the response to that was a bit mixed. We have the Gibbs case, which has been referred to, which many hold very dear in the UK. And we are now getting ready, I think this is fair to say, to publish the government response. But I can't tell you what it is. As ministers have to agree it, and then we have to publish it. So patience, please. We'll be there soon, and you'll see what we're proposing to do going forward. Is that good enough for you?
Excellent. We are looking forward.
Better.
And just to respond to Allan and then back to you, Stacy, that it's true that, in particular, Judge Glenn has taken a very clear approach regarding the broad interpretation of the relief provisions, but it isn't always shared in the same way, even within the United States, by all courts. So I would say that even in the United States, that clarification, looking back at various case law, that clarification would be helpful within the United States, but also to parties invoking the Chapter 15 model law in the United States to know exactly what can be done. And then, as I said, also leading other countries, encouraging other countries to follow suit and sort of promoting a more uniform, enhanced cross-border insolvency framework.
Yes, it is true that a very few judges in the U.S. don't always agree with Judge Glenn.
Judge Gropper said that he states UK law with trepidation. I state everything in this room full of experts with trepidation, but based on Judge Gropper's and Irit's presentations, it seems like the answer to whether the model law on recognition and enforcement of insolvency-related judgments, at least in those two panelists' estimation, is a complement, in fact, to the model law on cross-border insolvency. But there are implementation challenges that relate to other local laws and other conventions that have been adopted. And so, Rodrigo, what are the challenges that are posed by the model law on enforcement of judgments in that regard? And Pedro, if we could get the next slide, please.
Yes, thank you. I'll try not to be redundant to what has already been said without changing the subject. A way to do this is to remind us that it is a worldwide instrument, and there are also, well, jurisdictions not directly affected by the Rubin case, and I thank Susana for having cited the Sabena case, which was one of the drivers also for at least one civil law jurisdiction to address the issue of insolvency-related judgments. Of some civil law jurisdictions, because some others, like the EU jurisdictions, they wouldn't necessarily see the problem or the necessity to have these instruments. They have provision on insolvency-related decisions in the EU insolvency regulation. They have a full set of recognition instruments. There is the Brussels regulation referring to commercial decisions. There is the insolvency regulation relating to insolvency decrees, and within that regulation there is a particular paragraph that covers the field in between, which is insolvency-related decisions that are not an opening decisions or a closing decision of an insolvency proceeding. So the problem would not emanate from those countries, but from outside the EU. And the Sabina case originated outside the EU context in the context of the Lugano Convention. The Lugano Convention is a parallel instrument to the Brussels regulation. There's the same in there. It's just intended to cover non-EU states like Switzerland, Norway, and Iceland. The UK used to be in there. It ejected itself out first. It then tried to enter again through the visitor's door, but the European Commission said, well, Norway and Iceland and Switzerland, they're European enough, but not the UK. You're not coming back through the visitor's door either. So that's the state of play at this time. And there we have the situation that we do not have a clear statement on how these provisions are treated. And this is the same situation under the Hague Judgements Convention. Both the Hague Judgements and the Hague Choice of Court conventions, they exclude insolvency proceedings, but also insolvency-related. They use the terminology that also the Brussels regulation uses, that the Court of Justice of the European Union has defined as covering certain types of decisions. And that is what has created that ominous gap. The gap between the instruments that we have and the instruments that we have in The Hague and Lugano. And this is the gap that was intended to be filled, and that has been filled through the UNCITRAL 2018 model law. I think it's been a bit a victim of that obsession with minding the gap, because as you see, well, this here in the slide, a way to avoid gaps is to create overlaps to make sure there's no gap, and that's a little bit what this provision, what this model law provision does. It goes a bit too far into the commercial decisions, a tiny little bit too far into what would not necessarily be insolvency-related decisions, but mostly, and that's I think the major problem, it clearly steps into the territory of insolvency decrees by also covering, for instance, discharge decision. I know this is controversial in certain jurisdictions, but in most of them you would say you have invaded the territory of the model law. And well, this could be a problem that could be solved, but if you want to see where a problem arises as a consequence of that double overlap, you have to look at Article 14 on the recognition, or better say on the non-recognition of decisions. It has no less than 8 grounds for refusal of recognition. And this record number of 8 grounds for refusal is actually the consequence of having to cover all kinds of decisions of such different nature. You wouldn't find in the Hague Convention ground for refusal because a decision materially affects the rights of creditors generally. You won't find that, but you find it in our model law. Or you wouldn't find a ground for refusal because there is possible interference with the proceeding. That would not be sufficient to refuse. But we have all these totaling 8 grounds for refusal as a consequence that we have to think of such different kinds of decisions. So, and I'm glad you have that on the record, what I'm going to say, but I think the approach of the UK is a sensible one. It really does make sense to separate Article X from the other issues. It might have been a good idea to separate those 2 issues from the beginning and to solve the Rubin situation with one instrument and to address insolvency-related decisions with another instrument. But as the example of the UK shows, there are these possibilities to think about that in the implementation, to take this model law as a source of ideas. We have very valuable material in here. We have a definition that is really useful. Once you isolate the elements of the dissolution that are intended at solving the Rubin problem, which are not part of the solution of what is an insolvency-related judgment, and once you also separate the grounds for refusal, which are addressed at the Rubin situation, from those that are intended to respond to really insolvency-related decisions like an avoidance claim or like the ones that were at the basis of the Sabena cause, where the Swiss court said that subsequently, as a consequence of the insolvency of the debtor, the decision had become insolvency-related and therefore it could not be decided abroad, which is, of course, a bit a strange argument. But if you look at the definition today, you would see that the Belgian court, they had multiplied the claim by 10 by arguing that under Belgian insolvency law, the non-payment of a claim that had led to the insolvency, had caused the insolvency, was liable for the total damage caused by the insolvency, which was then 10 times the amount, and that would not be recognized. And I think the Swiss courts, they just tried not to recognize that decision by any way, including a bit particular arguments that brought Belgium before the International Court of Justice, which is not, well, the diplomatic way to solve issues. But so to sum up, I think there are ways to separate those two issues and to implement the best of what is in this model law by addressing the two issues separately, but looking at the very interesting provisions of Article 14 on indirect competence that I think could serve as a very good model for legal reform all over the world. Forget about the well, not forget, but don't think always of the concept that implementing a model law means copy-pasting it. Think at the big ideas that are in there in those articles. That can also be a way of implementing it.
And so picking up on what you said about the UK consultation being a reasonable way to address this gap, I'm going to go back to our discussion, our brief discussion on harmonization with the model law on cross-border insolvency and the concept that the model law on recognition and enforcement of insolvency-related judgments is a complement to that law. Is it too complicated to be, in jurisdictions where the model law on cross-border insolvency has been adopted, is the model law on recognition and enforcement of insolvency-related judgments as a standalone document, a standalone body of law, too complicated?
Yes.
Now, Judge Gropper,
I
on
think
our
so.
calls,
I think so.
on our calls in preparation for this panel, you had yes was the first word that came out of your mouth, followed by probably about 5 minutes worth of other words.
Well, I won't inflict that on.
You'll
on
temper.
But no, I do think that the substance of the law, as I think has been indicated by Professors Mevorach and Rodriguez, that it is complicated. Article 14, which was just referred to, and lists, 8 or 10 reasons to deny enforcement of a judgment, is complicated, and it's complicated in part because there's a separate law contemplated. And the law in this area, at least in the United States, is mostly a matter of court created law. It's mostly a matter that comes down to just due process, which I think could be more easily built into the statute. I think when there's an exception for a judgment that materially affects the rights of creditors, that's in there because of the second part of that, and the judgment affects creditors generally, and there's no adequate or sufficient protection of creditors as required by Article 22. So if you adopt this as a simple amendment to the model law, as the English, I think, hopefully are showing the way, it's much, much simpler and much more direct. But I should add, just for completeness, that the UNCITRAL Secretariat and Samira Musayeva, the representative, is, I believe, here today, has at great length and with a great deal of effort put together a document that's on the UNCITRAL website that integrates the model law on insolvency-related judgments as a whole into the model law on cross-border insolvency, and also integrates the model law on groups, which we are not really discussing today. And it's difficult, it's complex, but it can be done. And I think if any country is likely to adopt this law, it will be adopted as an amendment to the existing model law or Chapter 15 in the U.S., if it's adopted.
Just to add to that I think it's not just a matter of complexity. I mean, if something is a little bit complicated, we can handle it, but I think it is not just a matter of complexity, but potential inconsistency, as I try to show. And so I think it is important. I agree with Allan that for countries that have already adopted the model on cross-border insolvency, probably the best way is just to add an amendment to it. But even if you haven't yet adopted the model on cross-border insolvency, MLCBI, still I think that the best way would be to adopt the MLCBI and then amend or adopt it already with an integration of the bits from the model on judgment. So in any event, the best way is to base it on the MLCBI with the relevant amendments. And when you do those amendments, it's primarily Article X and clarifying Article 21. This is the most important bit of that amendment and clarification. But then if we look at the safeguards, it's not just complexity. Some of them will be just consumed in the public policy and adequate protection safeguards that are already adopted, that are already there in the MLCBI. Probably that would be enough. And then you probably need another of the safeguard about inconsistency with another judgment, which is sort of obvious, I think, to a judge, even if you don't have it in there, but you can amend and say, well, if it's inconsistent, also you shouldn't enforce. And the other jurisdiction bases are not relevant within the model on cross-border insolvency. If you recognize a main or non-main proceeding, that is enough. You don't need additional grounds to refuse. You may have a different sort of section in your amendment for those more rare circumstances where you would want to potentially enforce a judgment not emanating from a main or non-main, and then you may want some additional safeguards. So you do need to not copy-paste in this case if you want to amend the model on cross-border insolvency in a sort of consistent way, consistent between the two models and consistent with the general framework based on modified universalism, namely supporting, assisting, primarily a main proceeding and to a more limited extent other type of proceedings.
So we got the 5-minute warning probably about 7 minutes ago, but I hope Evan will indulge us to see if anyone has any questions that they want to pose to the panel before we wrap up. So thank you so much to everyone here and to the panel. And I will turn it over to Evan to introduce the next moderator.